Hello, everyone, and a very good evening to all of you. So, today we are going to understand about law of contract, which is the part of business law. But before I start my discussion with law of contract, firstly, being a CA or CS student, it is very much important for all of you to understand what is law. What is the purpose of creation of law? Why the law has been created? So, the law has been created for the betterment of society. The simple purpose of law is to govern the society, right? Now, as we know that we are living in a society where there are lots and lots of antisocial elements are present. Now, how to control those antisocial elements? Suppose if we are not having any law, let's assume a picture widely where we are not having any law. If someone commits murder, someone commits rape, extortion, robbery, dacoity, there shall be no punishment, right? And this will create a mess in the whole society. So for the betterment of society, for the governance of society, we require certain rules and regulations, certain codifications. These rules and regulations combinedly known as law. Now there is another purpose of law, that is to create social institution like marriage, caste, religion, etc. Now, what is the purpose of these social institutions? Again, these social institutions are made up for the purpose of betterment of society, for the better governance of society. Now, let's assume there is no social institution of religion or no social institution of caste or marriage. That will create a huge chaos in the society, because what the people will start doing, like suppose someone wants to marry with one girl, two girl, three, four, and n number of girls. He can do it if there are no fixed regulation or social institution available to stop it. So the sole purpose of law is for the governance of society. Governance of society for the purpose of creating peace, harmony in the society. And along with that, there is another purpose of law, that is to protect integrity and freedom of an individual, right? So if there shall be no law, obviously there are going to be a huge problem in the society. Why? Because the people will not have the right to freedom. And if suppose there is some problem in the society and I want to speak up against that problem, how I'll be able to speak up if there is no freedom in the society? So again, the sole purpose of law is to create integrity, harmony, freedom, peace, and again obviously the good governance of society. So I think this much introduction is enough to understand what is law. Now let's understand in detail about law of contract today. So basically all the contracts in India are governed by a single book of law, that is Indian Contract Act 1872. Now this book has various provisions, right, which are known as sections. So, as per section 2H of Indian Contract Act 1872, what is a contract? An agreement enforceable by law is a contract. Now, the obvious question should come into your mind, what is an agreement? When we can say that this is an agreement, and when we can say that this agreement has converted into a contract? So as per this definition, we can easily understand that any agreement which is enforceable by law is a contract. So any agreement which is legal is a contract. But now the question comes, what is an agreement? So we are going to discuss in detail what is an agreement and how it is different from contract. But before moving towards next slide, I would like to mention this thing specifically to all of you, as physics is incomplete without three laws of Newton, as trigonometry is incomplete without Pythagoras theorem, in the same way Indian Contract Act is incomplete without the chart mentioned on this particular slide. So if you are not able to understand anything in this particular child, I expect you to put up as many questions as possible, because if you are not going to get the clarity of this particular thing today, for rest of your life you are going to face problem in understanding law of contract. So let's understand it through a very simple example. How does a contract happens? So it starts from an offer or proposal, and then when the proposal has been accepted, it turns into a promise. When promise meets with consideration, it turns into an agreement. And when agreement is enforceable by law, it turns into a contract. That is something which is technical. Now let's understand it by a practical example. Suppose I want to purchase a candy worth rupees 10. So I went to a shopkeeper, to a particular shop, and I stated to the shopkeeper that, sir, I want to purchase a candy worth rupees 10. So what I did, I made an offer or proposal to that shopkeeper. Now that shopkeeper has two options. Either he can accept my offer or he can decline my offer. Suppose I state to the shopkeeper that, sir, I want to get a candy worth rupees 10, and the shopkeeper says, yes, I'm ready to sell it to you. What he did, he actually accepted my offer. Now, and there might be the cases he might deny. If he denies that I'm not ready to sell it to you, what has happened? He hasn't accepted my offer. If the person to whom I made the offer, like that shopkeeper, right? I made the offer. If he doesn't accept it, it shall not turn into a promise and it shall not proceed towards creation of a contract. So it is very much important and necessary that all these conditions should be fulfilled for creation of a valid contract. Now let's assume that that particular shopkeeper has agreed that, okay, I'm ready to sell this candy to you at the cost of rupees 10. So what he did, he accepted my offer. Now once he accepted my offer, he shall be entering into a promise. Not only he is going to enter into a promise, but also I am also going to enter into a promise. So let's understand it through a practical example. I state to the shopkeeper, sir, I want to get a candy worth rupees 10. He says, okay, I'm ready to sell it to you. Now what is the promise from my side? That I am going to pay him rupees 10, right? And what is the promise from his side? That he is going to give me that candy. And now neither of us, neither me nor that individual shopkeeper, can deny or step back from its promise. So both of us have entered into a legal promise. Now, suppose if I take the candy and does not pay him rupees 10, he can go to the court and file a legal suit against me. And let's assume in the different case that I have given him 10 rupees and he doesn't give me the candy. Again, I can go to the court and file a legal suit against that shopkeeper. So it is a legally enforceable promise. Now, when promise meets with consideration, it turns into an agreement. Now, what is the meaning of consideration? This word consideration is derived from the word consider. What is consider? Consider means giving value or giving weight to someone's statement, right? How does it work? Let me tell you. Suppose today we are having a mock test and you are late for the class, right? And you came 5 minutes late, and I am working as an invigilator in the class. You, as soon as you start entering into the class, I ask, why are you late? You says ki, sir, I have got my bike or car's tire flat today. That, or probably there was a lot of traffic today. That was the reason I was not able to come for the mock on time. So I was like, okay, I'm considering your case today, but be careful, do not get late next time. So here what I did, I considered, or I have given weightage to your statement. I have given weightage to your statement. Now in a contract also you give weightage to something. You give weightage to something. Now let's go back to the example I have given you. Like in this candy transaction, why I am giving rupees 10 to the shopkeeper? What I am getting in return? That is candy. So I am giving weightage. So for me, I am just writing for Sudhar, the weightage is that candy, right? And why shopkeeper is giving me that candy for 10 rupees. So for shopkeeper, the consideration is, or the weightage is that 10 rupees. So in a simple language, we can say in a particular contract, whatever you are getting in return is a consideration for you. Suppose I am teaching you, right? And you are paying some fees. What is the consideration for you? To get the goods and services from our institute, right? And why you are paying that fees? To get those goods and services. So for you, the consideration will be those goods and services. And why I am teaching you? Because I am getting some remuneration for the same. So for me, the consideration will be that remuneration, right? Which shall be definitely deducted from your fees, right? So it is a fair transaction. I hope this thing is clear. Now, when promise meets with consideration, it turns into an agreement. What is an agreement? When two party agrees to do something for each other in a reciprocating manner. What is reciprocating manner now? Reciprocating means vice versa. If you'll do this, I'll do that. That is called reciprocation. So when I went to a candy shop and asked for the shopkeeper that I want to purchase a candy worth rupees 10, right? I made a reciprocating promise that I shall pay you rupees 10 only when you will give me the candy. The shopkeeper also entered into a reciprocating promise with me that he will give me the candy only when, yes, let me know in the chat section. Yes, exactly. Very good. Only when I am going to pay him rupees 10. Right? So this is an agreement. When agreement is enforceable by law, is a contract. Now, as we all know that the subject matter of the contract in this particular example is candy. And selling and purchasing of candy is legal in India till now, right? So it can be considered as a contract. I hope this thing is clear to all of you. If anyone has any doubt, just let me know. Clear? Okay, fantastic. Now, let's differentiate the agreement and contract. Now, let's try to differentiate between these two. As we know that agreement enforceable by law is a contract. So now let's take another example to understand that how agreement is not a contract. In what cases an agreement shall remain an agreement and it shall not turn into a contract, right? Let's understand this. So let's take another example. Suppose Mr. A is there and Mr. A goes to a drug peddler, right? Drug peddler is the one who sells drug for illegal purpose, right? As in India, drugs cannot be used for recreational purpose, and if someone is selling drug to another person for recreational purpose, that person is considered drug peddler. So suppose A goes to a drug peddler and gives him an offer that, sir, I want to purchase 20 gram of cocaine. Cocaine is a drug, right? So what he did, he made an offer. The drug peddler says, okay, sir, I'm ready to sell it to you at the cost of rupees 50,000. So what he did, he accepted that offer. Now, once he accepted that offer, it shall turn into a promise. Now we have to understand that there are reciprocating promise, right? A has agreed that he is going to pay drug peddler rupees 50,000 and the drug peddler has agreed that he is going to pay drug like 20 gram of cocaine to Mr. A, right? So there is a promise. When promise meets with consideration, it turns into an agreement. So what is the consideration for Mr. A in this particular case? What he is getting in reward in this particular transaction, that is drugs. So for A, the consideration will be drug. And what drug peddler is getting in consideration? He is going to get rupees 50,000. So for him, the consideration will be that 50,000 rupees. Now it is an agreement, right? They have entered into a agreement which is having mutual uh, confidence, mutual consideration, and they are having trust and confidence over each other. But they have to see whether selling and purchasing of drugs for illegal purpose from a drug peddler is legal in India or illegal. It is illegal. So it shall not turn into a contract. Why? Because it is not enforceable by law. It shall remain only an agreement. I hope this thing is clear to all of you. So now we can simply say that all the agreements which are enforceable by law is a contract, and all the agreements which are not enforceable by law shall remain only agreement. They shall not turn into a contract. I hope I made this thing clear. Now, let's deep dive into the concept of Indian Contract Act in detailed manner today. Now, let's understand what is a proposal and how it is important for us to understand the concept of proposal. Now, before I get into the definition of proposal, I would like to tell you, in your exam, either you are getting offer or proposal. Do not get confused. They both are same, because under Indian Contract Act, they nowhere use the word offer. Rather than that, they have used the word proposal, right? So there is no difference between an offer and a proposal. Now, as per section 2A of, yes, Indian Contract Act 1872, right? What is the definition of proposal? When one person signifies to another his willingness to do or to abstain from doing anything. Why? With a view to obtaining the assent of that another to such act or abstinence. He is said to make a proposal. Now let's understand this thing. Suppose when one person like me signifies his willingness to another means, let's take the example of candy. So here to another person will be that shopkeeper, right? So when one person is Sudhar, signifies his willingness to another, right? Signifies to another his willingness. Willingness means his intent, right? To do or to abstain from doing anything. Now here we have to understand that there are two categories of proposal. One is called the positive or affirmative proposal. Another one is called negative proposal. In the positive proposal, we state to another person that if you will do this, I'll do that. For example, I go to the shopkeeper and says to him, if you will give me the candy, I shall pay you rupees 10. So that is a positive proposal, affirmative proposal. Here I am paying him to do something. Or in some cases, what we do, we abstain someone. Abstain means we prevent someone or we stop someone from doing something, right? From doing something. And if that person follows our willingness, our intent, and prevent himself or herself from doing that thing, then it can be considered as negative proposal. So let's understand it also by an example. How does negative proposal works? Suppose I go to Mr. A, right? And I ask Mr. A that if you will quit smoking, right? I shall pay you rupees 50,000. Now here what I am doing? I am paying him money for not doing something. I am preventing him from doing something. So it is a negative proposal. Remember one thing, both of the proposals are legal, right? In one, in the case of positive or affirmative proposal, you ask someone to do something, then you will pay him the money. In the negative one, you stop someone from doing something and then you pay him the money, right? And whenever you make a proposal, what is the purpose behind it? Whenever you signify your intent to another person to do or to abstain from doing anything, why? Because you want to know or obtain the assent. Assent means opinion. You want to know the opinion of that another. That another means that shopkeeper, or in case if I'm making an offer to Mr. A that please, like if you'll quit smoking, I shall pay you 50,000 rupees. So here that another person is the person to whom I am making a proposal, right? To such act or abstinence. If it is a positive offer, so obviously I am going to ask his opinion on such positive action, or we can say act. And if it is based on a prevention or denial, then we want to know the opinion of another person on such abstinence, right? He is said to make a proposal. I hope this thing is clear. So let's understand this definition one more time. When one person signifies to another, when one person signifies to another his willingness to do or to abstain from doing something. Like I'm going to the shopkeeper and asking for the candy, that is to do something. Or to abstain from doing anything. I'm going to Mr. A and saying that stop smoking from today onwards and I shall pay you rupees 50,000. Here I am stopping him or preventing him from doing something. Why I am doing this thing? The reason behind is I want to know the opinion of another person, whether he is interested in my offer or not, right? So let me tell you what is the practical implication of this. Suppose you go to a particular shop and you says, bhaiya, can I get a packet of chips worth rupees 10, uh, American cream and onion flavor, right? You can directly see in the racks kept outside the shop that yes, they are having that packet of chips, but still you ask those shopkeeper na, whether they are interested to sell that packet of chips to you or not, right? You cannot do this thing that you have thrown rupees 20 on their counter and took a packet of chips and you escaped from the place. It cannot be done. Why? The reason is very simple, because we want to know the opinion of another person on such act or abstinence based on the nature of your proposal or offer. He is set to make a proposal. I hope I made this thing clear to all of you. Now let's understand the rules of a valid proposal. A valid proposal can be either express or implied. Now, how we can express something? Our expression can be made either by oral or by writing, right? Or how something can be implied either by gesture or by circumstances. So let me tell you how does it work. Suppose um, you went to a particular pizza shop and you state to the shopkeeper, the store manager, or the person standing on the counter that I want to get a cheese burst farmhouse pizza, medium size, right? Worth rupees 570, right? What you did, you made a proposal, but how you made it? By words, by oral communication. So that is, our offer can be oral, or sometimes it can be in writing also. When it can be in writing, suppose I want to inform some of the people in the society that I have lost my pet. Whoever will find it will receive the cash prize of 50,000, right? Here, I have made a newspaper advertisement of the same. So here I am making or communicating my proposal or offer in writing. So it can be either oral or in writing. But, but in some cases it can be implied also. Again, it can be implied by gesture or by circumstance. How does it work? Let me tell you. Suppose you want to travel somewhere, right? You want to get at some local place and you are using a public transport, right? A public transport bus. So you waves your hand like this way, like this, right? The bus stops. You boarded inside the bus and the bus starts moving. Now, the bus reaches to your destination, you moved out of the bus, and the conductor, the bus driver, person asks you to pay the money. And you were like, why should I pay you the money? Do I have stated something? Do I have communicated something orally that I want to board in your bus? Or do I have given something to you in writing that I want to board in your bus? Then what the bus person will say? That, sir, अगर आपने सुधार सर का लॉ ऑफ कॉन्ट्रैक्ट वाला सेक्शन अच्छे से पढ़ा होता तो आपको पता होता कि some of the proposals can be implied also, implied by gesture. Waving your hand like this way means you want to board inside the bus and you are ready to pay the fare of that public transport bus. Got it? Clear? Just give me a thumbs up if it is clear to all of you. Now, heading towards next. Some of the proposals can be implied by circumstances. What is the meaning of some of the proposals are implied by circumstances? Let's take the example of this. Let's take the example of Mr. A, right? Mr. A was driving his car, right? I'm poor in drawing, so pardon me for that. Let's assume this is the car of Mr. A. Now, Mr. A's car collided with a heavily loaded truck, right? And Mr. A received severe injuries. He has become unconscious and he started bleeding. Now, there was a passerby, right? Mr. B. Now, as soon as Mr. B sees Mr. A in that poor condition, he picks up Mr. A and shifted him to the nearby hospital. Mr. A remained unconscious for next 48 hours. During that period, Mr. B has paid all the medical bills of Mr. A, right? Now, once Mr. A comes into his senses after 48 hours, so Mr. B states to him कि you had a tough accident 2 days ago, 48 hours ago, and you have been shifted to this particular hospital by me, and I have paid all your medical bills worth rupees 2 lakh till now, right? By hearing this news, Mr. A might get a serious heart attack condition again, but technically Mr. A is liable to pay or reimburse that 2 lakh rupees to Mr. B, right? So this is called implied by circumstances. Here Mr. A neither stated anything to B orally, nor given anything in writing, neither made any kind of gesture, but by the circumstances, it is implied for A that whatever help has been done by B to A in terms of finance, Mr. A is liable to reimburse that. Clear? Now, heading towards next. Whenever you are making an offer, it must contemplate to give rise to a legal relationship. Now, what kind of relationship is a legal relationship? The relationship where both the parties are having reciprocating promises, enforceable in the eyes of law. Now, what does it mean? Let's understand this thing. Let's take the example that I'm teaching you, right? Now, today I'm like, I have changed my mood and now I won't teach you people. What you people will do? You people are going to file a lawsuit against me, right? And why you are going to file a lawsuit against me? Because there is a reciprocating promise from my end that I am going to teach you. When you made an offer that, sir, I want you to teach us, I have agreed that I'm going to charge you the fees, and there was a reciprocating promise from my end that I'm going to teach you. Now, if I breach my promise, definitely you can go to the court because we are into a legal relationship. Which kind of legal relationship? Here, I am the service provider, right? and you people are acting as a consumer of that service. Now, let's reverse the case for a minute. Suppose I'm teaching you, but you are not paying the fees. I can file a legal suit against you. Why? Because there is a legal relationship between us. So, in a simple word, we can understand legal relationship means a relationship where any party denies from its promise, the other party can go to the court and can file a legal suit, right? I hope I made this thing again clear to all of you. Now, next thing is terms must be certain. So, to make a valid proposal, the terms of the proposal have to be certain. Suppose you comes to me and you ask me, sir, I want you to teach me for CA foundation. I was like, okay, I'll teach you, but I shall charge the fees of either rupees 50,000 or rupees 1 lakh, right? Either rupees 50,000 or rupees 1 lakh. Now, here it is important to note, I haven't stated that in what case I am going to charge 50,000 and in what case I am going to charge rupees 1 lakh. So, here I haven't made the terms clear. So, the terms of a proposal have to be very much crystal clear, and they should be interpreted by both of the parties to the contract in the same way. Now, here let's take another example that I comes to you and I state to you that I want to teach you for CSCS, and if you have scored more than 80%, then you will have 2 hours class. If you have scored more than 90% in class 12, then you are going to have 1 hour class. If you have scored more than 75%, less than 85%, you are going to have 3 hours class. If you are wearing white color dress and scored more than 85%, you are going to have 1.5 hour class. But if you have scored more than 85 and less than 95% and wearing black color dress on a particular day, you are going to have 3 hours class. If it is Diwali on Thursday, you will be having complete off. But if it is Diwali on Wednesday and the sunrise is before 6:45 and you are wearing a pink color dress and scored more than 75%, less than 85% in your class 12, they are going to have 4 hours class. You will be like, Prabhu, ho gaya. I'm done with my CSCS preparation. Now I don't want you to help me, right? So here, whenever a person is making an offer to another person, he has to make the terms very much certain and clear. Simple. When you came to us, right, or when we came to you that if you want for your CSCS preparation, we can help you, we have stated you कि these are the goods we are going to provide you, these are the services we are going to provide you, this is the faculty profile we are going to provide you, everything was crystal clear. Let's take another example. I reached to a particular shop and I state to the shopkeeper, right, like he is dealing with groceries, various kind of groceries. I state to him that, sir, please give me some material. It is a very vague statement. What material? Whether I want to get a packet of semolina or besan or gram flour or um, like all-purpose flour or wheat flour, rice flour. I haven't specified anything. I have stated I want some sort of material. The material can be oil also, ice cream also, pizza base also, some uncooked pasta also. What I am seeking. So I have to be very much clear and certain when I am making a proposal. Now, next thing is a proposal may be either specific or general. Now, a proposal, if it is specific, then it can be accepted only by the person to whom it is made. But if it is general, it can be accepted by anyone. Now, let me give you an example of this. Let's understand it through an example. Like, suppose I state to Mr. A that I want to sell my phone to you at the cost of rupees 5,000. Now, this offer is restricted only to Mr. A. Only Mr. A can purchase it at the cost of rupees 5,000. No one else can purchase it at the cost of rupees 5,000. Simple? Clear? Now, Suppose I state that whomsoever is sitting in this class can purchase my phone at the cost of rupees 5,000. It is again specific. It is specific to the class. So only the classroom students can purchase it at the cost of rupees 5,000. Someone who's not present in the class as of now cannot purchase it. Now, let's understand about general offer. Suppose I make an offer that I want to sell my phone at the cost of rupees 1,000. That's it. I haven't specified to whom I want to sell, what is the specific condition I am seeking in the buyer who has to purchase my phone. Then it is a general offer. It is open for all. Anyone having 1,000 rupees can purchase my phone. I hope I made this thing also clear to you. Now, rules of a valid proposal. Let's understand rules of a valid proposal with some more points. Now, invitation to offer is not an offer. It is very much technical point. Most of the students get confused with this particular point. Invitation to offer is not an offer. What does it mean? Now, for that, firstly, we have to understand what is invitation to offer. So, when you invite someone to make an offer to you, that is invitation to offer. It is not an offer. As we have understood, to make a contract, the basic stages are offer plus acceptance equals to promise. Promise plus consideration is equal to agreement. Agreement plus law equals to contract. But in some of the contract, a stage comes prior to offer, and that is invitation to offer. So when one person invites another to make an offer to him, it is an invitation to offer and not an offer. Let me give you an example. Suppose you go to a pizza shop, right? And that person standing on the counter, he gives you the menu card, right? And from that menu card, you pick one pizza, and let's say like um, Mexican green wave, medium size cheeseburger pizza, right? You picked up that pizza and you want to place the order for that pizza. Now, that particular pizza has the topping of mushrooms. And when you try to place the order, the person standing on the counter says, "Sir, ma'am, I cannot provide you this particular variety of pizza because we are not having mushroom in our stock as of now." Now you cannot file a case on that particular person standing on the counter. Why? Because by giving that menu card, he was making an invitation to offer to you. By giving that menu card, he was inviting you to make an offer to them. And by looking at that menu card, when you try to place the order, what you did, you tried to make an offer to him. Now, it is up to them, he may or may not accept your offer. Simple. I think there should be no confusion in it. So, invitation to offer is not an offer. Let's understand another example. Suppose a particular company issues its prospectus, right? Where they invite you to subscribe to their share, right? By looking at the prospectus, you have deposited some money and you wanted to subscribe their share. But at the later stage, they denied that they don't want to give you the share in their company. Now you cannot file a legal suit against them. Why? Because that prospectus was invitation to offer. By looking at that prospectus, they were inviting you to make an offer to them. And by subscribing to their share, like depositing the money to purchase the share, what you did, you made an offer to them, which is up to their discretion. They may or may not accept it. Clear? So invitation to offer is not an offer. Now, next thing is that the offer must be communicated. Communicated to whom? To the person who has to accept it. So suppose I want to sell my watch, but I never state to anyone that I want to sell my watch. Then in that case, obviously my watch cannot be sold, right? It cannot be considered as a valid offer. Why? Because the offer has not been communicated. Now, next, spatial terms must be communicated in a spatial manner. What does it mean? Suppose I want, like I have went to a shopkeeper and I stated to him that I want 50 kg of sweets on 26th Jan, right? And on 26th Jan at 6 or 6:30 a.m. when I reached to his shop, he was like, "Sir, the order is not ready yet because you have stated you want it on 26th Jan. You haven't stated the time." And then I state to him that I am having a school and I wanted to distribute these sweets among the children of the school, and now the sweets are of no use of for me. I cannot do that. Why? Because when I was making the offer, I should have highlighted this special term to him specially, that I want the delivery on or before 6:30 a.m. because I want to distribute it into the school. Otherwise, these sweets are useless for me. Clear? So it is very simple. There is no rocket science in it. Now, offer should not contain a term the non-compliance of which would amount to acceptance. This is again a very interesting point which all of us have to understand. The offer should not contain a term the non-fulfillment of which would amount to acceptance. Let's understand it through an example. I have sent a letter to Mr. A. In that letter, I have stated to Mr. A that I want to purchase your car, and if you did not reply me after looking at my letter, if you haven't replied me in next 3 days of looking at the letter, I shall assume that you are ready to sell your car to me. Mr. A received my letter and he hasn't replied within the span of 3 days. I cannot file a legal suit against him for the purchase of car. Why? Because my offer, that letter, that particular information which I have shared with that particular person, Mr. A, has a term, the non-compliance of which has amounted to acceptance. I have put a condition that non-fulfillment of this condition shall be assumed as you have accepted my offer. Why this condition is there? Because we have to understand that contract is a shuttling process. It is a two-way process, right? Firstly, the shuttle goes from A to B, then B to A, then A to B, then B to A. This is how it works. So by making such kind of offer where I put up a condition of non-compliance would amount to acceptance, I have closed the window for next person, right? So it is very much important for all of us to understand that the offer should not contain a term, the non-compliance of which would amount to acceptance. I hope I made all of these things clear to you. If everything is clear, just let me know in the comment section, or if you are having any doubt, you can just let me know, right? Okay. So that is it for the day, guys. Going to see you in the next session in some other classes. Thank you.